live. This is Lawcall.
Good evening. I'm attorney Chris Young with the law firm of Perry & Young, and thank you for joining us tonight on Lawcall on WMBB. Tonight we got a packed show for you tonight. We're talking about family law, and there's been a lot of legislation that's changed over the last 6 months in the family law world over in Tallahassee. And so if you're going through a situation, custody, child support, or even alimony, you know, we may have some good answers for you on some questions that you may or may not have. But as always, our phone lines are open, 850-392-1544. If you don't feel comfortable calling us and going on the air, you can always email us at lawcall@wmbb.com. Tonight I have a good friend of mine, Mr. Rob Boyette. He is a prominent family law attorney here in Panama City area. And Rob, I mean, there's a lot to jump into right away with a lot of different statutes that just recently been passed by the Florida legislature that impacts the way people get divorced and how marital assets are split.
Well, and it's not just marital assets as well. We're talking about custody as well. There were three big changes by the governor this year in Tallahassee. Okay. The first being that there's a presumption now for custody of unwed folks that there will be 50-50 custody. It's a rebuttable presumption. That's a big change in law, a big thing for fathers out there. That's the big one. The other big thing is the alimony statute. The alimony statute, the governor has gotten rid of permanent alimony and made some changes to the statutes there. Those are the big two that come into mind right now.
Now those are, if you've never been through a divorce, thank goodness you never have to experience those. But unfortunately, you do this every day, day in and day out. Not unfortunately as a job, but unfortunately you see individuals having to go through this day in and day out. And explaining the old statutes versus the new statutes are, you know, there's a different rule book now.
Well, there is, and there's also a married versus unmarried. So before July 1st of this year, if you were unwed and you had a child out of wedlock, the mother was presumed the guardian or natural guardian of the child, and until you went to court, you had no rights. The fathers had no rights. Now, as it stands, you're both considered to have shared parental responsibility, meaning that you both have rights to the child. Now, there's still no designated time sharing or anything of that nature, but as of now, it's almost as if you were married and were getting divorced, and each party has an equal right to that child. That's the big thing for unwed couples.
Okay. Now what was? Let's just break this down for a second. What was the old law?
The old law was that the mother, for obvious reasons, was the natural guardian of the child. Okay. And until you went to court and got rights to that child, until you had a judge say, hey, we're going to put down a time-sharing schedule, we're going to give you shared parental responsibility, you know, that was it. The mother got the child. So in other words, if dad decided to take the child on a whim, even if he was on the birth certificate, the mother could go down to the courthouse, get a pickup order, and have the child returned to her. Okay.
So now you can't do that.
No, you can't do that. Everybody has it, and it's caused some issues. And I would suggest to everybody out there that essentially, you know, remember that you both have a child, and that child deserves your love, and keeping it from either parent is not a good idea. Eventually, you will be in front of a judge, and you will have to answer for what you've done. However, at this point in time, both parents do have a shared parental responsibility or are equally responsible for the child at birth, as long as the dad is on the birth certificate.
Okay. So if you have a custody question, feel free to give us a call. Phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com. Now, Rob, a second part of some major changes in our legislation has to do with alimony.
Correct.
Now, let's before we jump into what the new change is, what is alimony?
Alimony is support, and it's support for your spouse. And the way it's broken down, or you start with, before you get to anything, even in the new law, is does your spouse or the spouse you're getting away from have a need, and do you have the ability to pay? Okay. So before they get through anything, they're going to do that breakdown and say, does the spouse that you're leaving have a need, and do you have the ability to pay? And that's done through financial affidavits, different disclosures. And
now that amount could be rather large, or it could be small based on the couple's assets or their standard of living, or
correct
lifestyle, I should say. Correct.
And what the legislature has done now is they've kind of put some parameters on it, at least as far as durational alimony and some other things of that nature. It used to be there was a presumption of permanent alimony in the state of Florida prior to July 1st of this year. Okay. That is no more.
Okay. So basically means a presumption is you're likely to get alimony if you get divorced before July 1st, 2023. But now it's different.
Yes, and what I used to like to tell my clients was it's a rebuttable presumption, but the judge is going to start with, this is what it is, tell me why it shouldn't be that way.
Right.
So now what they've done is gone back and changed some of the parameters. It used to be in the old law that a short-term marriage was anything from 0 to 7 years. A moderate length marriage was anything from 7 to 17 years, and a long-term marriage was 17 years and beyond. And that 17-year mark would be where the presumption for permanent alimony was.
Okay.
Now they've changed those rules. The rules are a short-term marriage is 0 to 10 years, a moderate length marriage is 10 to 20 years, and a long-term marriage is 20 years and beyond. And what they've done with this after the durational alimony statute is they put parameters on how long you can get alimony for.
Okay.
So after they do a bunch of other stuff that's involved, but really in a short-term marriage, you can go no longer than 50% of the length of the marriage. If in a moderate length marriage, you could
So you could get no more than 5 years.
Correct.
Okay.
Correct. And in a moderate length marriage, you could go no longer than 60% of the marriage.
Okay. So that would be 12 years.
I was told there'd be no math.
Okay. All right. Well, I'll do the math for you, man. I love math.
No, and then in a
Because
long,
you said 20 years, right?
Yeah,
Okay.
yeah. In a long-term marriage, at 20 years, it's 75%.
Okay.
Now they do add
That'd
in
be
an
15.
Okay. They do
Minimum
add in an exceptional circumstances type rule, but it's kind of a catch-all. But that's where the length comes in.
Okay.
Now the amount of money is supposed to be no more than 35% of the disparity of the net income between the two parties. And now we're getting into stuff that's way more we don't have time for really. But
okay.
But basically you have to get financial affidavits and figure out what the incomes of both parties are. And this is if you're actually awarded alimony, which means there's way more that goes on before that.
So it's a lot tougher now to establish alimony and then to receive an amount that you would have received prior to July 1st, 2023, I guess.
And I don't know that it's tougher, but the amounts seem to be different. They seem to be trying to put either a cap on it or make it reasonable. The days of, I'm going to take you to the cleaners are probably over,
okay.
for the most part.
Okay.
And then there was one other law that got changed that was big this year, if you want to discuss that as well.
Okay. We do have a caller. Okay, we do have a caller on the line. Mary from Alabama, or Andalusia, actually. Go ahead with your question, Mary.
Yes, sir. I was wondering if in February of 2016, went to Defuniak Springs, Florida, bought a marriage license, and we came back to Alabama and got married that day. And it was registered at the probate office in Alabama. Then we crossed the Florida line and came back. Are we married? He says we're not married.
That's it. I am definitely going to defer to Mr. Boyette about that one, Mary. That's a good question.
And I'll be honest, I'm not sure. The marriage license out of Florida is the big thing. I don't think it necessarily matters where the ceremony is performed. I think it would matter where you recorded the marriage license. In other words, I don't know that you can record a Florida marriage license in Alabama, and that would be a question for an Alabama attorney. But a Florida license would need to be recorded in Florida, I think. Now, there's all kinds of fair faith and credit issues that may be on there, but honestly, I don't have a better answer than that for you right now, and I'm sorry.
Mary, I do have a follow-up question. Are you going through a divorce or a separation, or are you just trying to figure out if you're married or not?
Well, we're trying to figure out if we're married or not, but I spoke with a lawyer, and he seems to think that we are. The ladies at the probate court in Covington County where it was registered, they said we are married.
Well, here's what I'd do. If you want to stay married and you want to make sure you're married, just go down to Washington County there and just have another ceremony in Florida, and get married again. Can you? Well, it's kind of like getting baptized twice.
It is.
You want to make sure that you're baptized.
We have a lot of cases where we get cases from out of state, and we take their decrees and we domesticate them down here, and that may be what happened up in Alabama. But if the registrar in Alabama is saying your license is good up there, and I think that's where I'd start, as I check with the folks you filed the marriage certificate with. If they're saying it's good, I might want some sort of order or something just to make sure, but that's where I would start.
Okay. Mary, thank you for your question, though. Phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com. We're going to take our first break of the evening, and we'll be back in just a moment. And welcome back to Law Call tonight. We've got Rob Boyette on the show with us, and we're taking your questions related to family law. So family law is a broad topic. It could be adoption, it could be custody, or it could be child support or alimony and divorce. So if you have a question, feel free to give us a call at 850-392-1544, or you can always email us at lawcall@wmbb.com. And we actually do have an email question that came in through the break. It is from AJ. And, well, okay, this is actually Elizabeth. I'm sorry. We have one from AJ coming in just a second. Well, here's AJ. Asking for a friend. That's always a great way to start a question. Husband is cheating and wife has proof. They have 4 kids together. Husband has odd jobs, less than $30,000 yearly. Wife is $100,000 salary. Will she be splitting assets? If husband commits adultery, shouldn't he be at fault? Unfair to take half her assets. What if he has abusive behavior? AJ, great question. Rob, let's just assume this is in Florida because I'm assuming it's where this came from. I think we're actually, just like our auto insurance, we're a no-fault state, right?
That's correct. So the short answer is yes, you'll be splitting assets. Florida is an equitable distribution state, and we are a no-fault divorce state. There are ways you could plead for unequitable distribution. There are ways to get money back. If you could prove that the cheating spouse or adulterer has dissipated marital assets on that other outside the marriage relationship, you might be able to get some of that money back. The abusive behavior, that's probably not going to come into play as much. Where all this stuff comes into play, Chris, though, is they have 4 kids.
Right.
Okay.
Now, abusive behavior would come into play probably
absolutely.
with the custody battle,
yes.
right?
In fact, all of this stuff will come into play with the custody battle. Even the adultery comes into play. It's not a super factor or things of that nature, but it comes into play. There are like 20 factors when you're dealing with child custody. And abusive behavior it actually triggers a presumption.
Okay.
There are a lot of presumptions in family law. So if you are convicted of domestic violence in any way, shape, or form, it is presumed that you are detrimental to the child. And that starts the whole game for child custody at a whole different place. Once again, like I said, I like to tell my clients, if it's presumption, the judge says, we're starting here, tell me why I shouldn't stay here.
Okay. So are we still a no-fault state with equitable distribution with the new statutes, or are we not?
Yeah, no, still a no-fault state.
Okay.
Equitable distribution hasn't changed.
So the main thing was custody.
Yeah, custody
and alimony.
Right, and the new change that we didn't discuss is custody in general. When we're dealing with Florida doesn't even use the term custody. Everybody else does, but we have 2 separate things. We have parental responsibility and time sharing, and the governor signed something on July 1st for time sharing that makes it a presumption that if you guys are in the same area, 50-50 custody is the way it's going to start.
Okay. Well, you finished? I'm sorry.
No, yeah, absolutely.
I didn't cut you off. We have another caller on the line, a concerned mother from Calhoun County.
Hi, I was just curious if, so I was arrested. My husband filed for emergency sole custody, and I was not served anything. I'm wondering what my rights are as a mother.
Okay, so there are different things going on here. A, it kind of depends on what you got arrested for. B, if it's an emergency, they could file what's called an ex parte motion, and if that happens, even if you hadn't been served with it, they'll go ahead and grant a motion temporarily, and then you have about 14 days where you get a hearing in front of the judge to explain what's going on. Sometimes an arrest, it can be taken as a bad thing right off the bat, meaning even if it had nothing to do with the children, it puts you in a light that's not great. But you do have rights. They can't just summarily take your children away from you. They can't do all that without at least having you get some due process. Like I said, they will do an ex parte emergency motion occasionally. And if that happens, though, under the law, you're entitled to a hearing in front of the judge within 14 days.
Concerned mom, thank you for calling in. Rob, I mean, the thing that jumped out to me was, I've been arrested.
Mm-hmm.
And let's just take concerned mom's situation, her out of this equation. A parent has been arrested. Obviously, they're either separated or going through issues why the father would take the children or
right.
her existing husband. But what happens, I mean, obviously, if you get picked up for, I don't know, petty theft versus cooking meth, obviously that's a lot different.
Absolutely. Don't get me wrong, it's still going to be, they're still going to make some hay with it.
Okay.
You're setting a bad example for the child, but a petty theft charge at Walmart is not necessarily going to lose your kids or cause any problems. per se, but like you said, if you're arrested for methamphetamine or driving under the influence or anything involving substance abuse where you could just cast a bad shadow that maybe you could be doing these things in front of the children, then yes, that's going to be a different type of game.
Okay. We do have we'll get to our other email question from Elizabeth. Guys, if you can put that up for us. Elizabeth, if my husband and I are separated and about to finalize our divorce, is he entitled to part of any settlement I would get from a car wreck that I was in? The wreck was after we were no longer cohabitating and had nothing at all to do with him. Elizabeth, you do not realize how good of a question that actually is, because what we would normally do is basically if you were still married at the time of the accident, and depending on the situation between you and your ex-husband, we would probably err on the side of caution, given the facts that you just presented, and we would make sure that your ex-husband or soon-to-be ex-husband had no claim in your settlement. Now, that can get a little contentious. There is a provision called loss of consortium, but he probably doesn't have a loss of consortium claim if you guys were already getting separated or prior to the accident, or as the accident was going on. I mean, the injuries after the accident. So, typically speaking, we would err on the side of caution to make sure that we get everyone to consent to a settlement and make sure that we're not dispersing funds where someone could come back later and say, hey, you owe me some of that money. But in this situation, I think you'd have a great argument to claim that your ex-husband or soon-to-be ex-husband has no claim to those settlement funds because his loss of consortium did not exist because you were actually separated. And, you know, Rob, that's a fancy term,
right?
A loss of consortium, and you guys deal with it a lot in the family law realm too. But loss of consortium basically, used to be described or defined as loss of sexual relations with your spouse. But now, over the years, as we progress as a society, it's actually branched out more than that: washing dishes, taking the kids to school, picking the kids up, cooking at the house, doing household duties, and all of those things are, if someone gets in an accident and they cannot perform their services anymore and they're depending upon their spouse, well, then that's where that claim arises.
Right, and I can tell you from experience with this, we get a lot of folks who do personal injury claims and have things like the case law on it has been fairly clear that even if you are married, as long as the funds are kept separately, when it comes to divorce, the claim is that person's claim solely alone. In fact, if I have clients come in, I tell them, like, well, look, if you are wanting part of this, then you need to get with the attorney on that and file a loss of consortium claim. Yeah. Because equitable distribution-wise, in a family law setting, you're not going to get that settlement unless you've taken that money and put it into a joint account or something else like that, where you've commingled assets, right, and then becomes a marital asset. So, talking about,
let's just skip ahead here. Probably a more pressing concern is a custody issue. Mm-hmm. Okay. Everybody says, hey, I'm the dad, I'm not getting the kids. My spouse, whether it's girlfriend or the mom, why does she always get the kids? And Rob, I think that's probably a $64,000 question, really. Why is it predominantly that the female or the female in the relationship always gets the child?
I think it's more of a matter of history, realistically. Now, we talked about this a little earlier. It kind of depends on what type of situation you're in. If it is a divorce situation, if the female ends up with the kids, it's a lot of times because mom has always done that. Mom has always taken care of the kids. She's never done anything else. Or she's the one who's primarily responsible for doing that in the marriage. If we're talking about a situation where a boyfriend girlfriend, they break up, or just you guys have a random encounter and have had a child. Before, like I said, the mother was the natural guardian of the child because it was very easy to know where the child came from. Right. Quite frankly, that's how they did it. And like I said, they've changed some of that stuff.
I think it still works the same way too, Rob,
it does, and it's still easier to do that. But now they've started to reward, I guess, fathers for stepping up. Yeah. Taking ownership and putting their name on the birth certificate, and then also acting out as a father and behaving as a father. And I think that's primarily the intent of the new law, is to not punish those fathers who have, decided.
Who are great dads.
Right, right. Okay. I mean, I've had cases before where I've had, mom calls up, says, I'm taking the child to dinner, then knocks on the door the next day and says, by the way, we're going to Chattanooga. See ya. And if dad hadn't filed anything, it's problematic. Yeah. And those are the things they're trying to stop, I think.
Good, good. We're going to take our last break of the evening. We'll be back in just a moment. The phone lines are still open at 850-392-1544 or lawcall at WMBB.com. Be back in just a moment. And welcome back to Lawcall. We got Rob Boyette with us tonight, and we're trying to do some speed question here just for one. I got one more pressing question, Rob, talking about family law. How do you calculate child support?
All right, the quick version of it is this. You will both have to do financial affidavits, but they take your gross income and her gross income, and they come up with your net income, and they determine, depending on how many children you have, using those incomes and a math formula that I could never explain, this is what it takes to raise a child with these two incomes. What also goes into the formula is how many days and overnights you have the child. In fact, it's overnights. That's how the state of Florida measures time sharing in the state of Florida.
Okay.
The number of overnights you have directly correlates to what you are going to get for child support. There are also two big deductions or credits: health insurance, child care. So if you pay for health insurance and you pay for child care, they're going to take that out of your child support. They don't want to, and it's not really a credit or this deduction. You're paying it one way or the other. They're just not going to hit you twice and make you pay it both ways. So those are the quickest ways to tell you how they do child support. But it's income based.
So it's statutorily, but it's income-based statutory. So basically, however much money you make, you're going to pay a lot more in child support.
Yes, the more money you make, the more child support you're going to pay. The way to reduce it is to have the child more time.
Okay.
But there is no, even if you have 50-50 custody, it doesn't bar child support. You're still going to pay child support if you make more money.
Good deal. Thank you, Rob. We're at our last segment of the evening. It's shout-outs. You want to?
Yeah, I'd love to say
it's your rookie night here, man.
Right,
so
right.
let's
hi, Savannah, if you're still up, I love you. Hi, Mom and Dad. Hi, Deb, if you're up watching this, my wonderful paralegal.
Okay.
That's all I got.
All right, man. So I've got my wife's supposed to be watching with Boss Man. I don't know if she is or not. She's probably sleeping. But my mama's watching as always. Trey Smith, Judy Smith, Pam Myers, our guys over at the Grand Merlin, and Gary Starr and Paula Frederick. And a very, very, very special shout out to my former office manager and one of my closest friends in the whole wide world, Miss Annie Jordan, lost her sister a few days ago. And our prayers and wishes, our prayers and thoughts are with you. And actually, Annie's living in Spain now, so I'm hoping that she's going to get to watch this through Facebook.
I hope she does. I love Annie. She was wonderful.
She was awesome. And also, happy Thanksgiving. So please
happy Thanksgiving, everyone.
Please be safe on the road. And if you've had a little bit too much partying, too much to drink, please, please, please call someone to come pick you up and have a safe and happy Thanksgiving. And same time, same place next week. Good night.